Hello everyone and welcome to another module of Economics and Law 1. I am Dr. Divyansha Kumar, Assistant Professor at Chitkara University, Punjab. Today, we will learn about the economics of the death penalty. In contemporary criminal justice systems, the death sentence has likely been the subject of the greatest discussion among penologists. India, however, has remained largely apart from the West in terms of public debate at large. Let us start this class with a discussion on the death penalty. The continued existence of the death sentence in the criminal justice system has always been a subject of great interest for many. In addition to the diverse and principled positions adopted in this discussion, the crux of the matter ultimately lies in the topic of deterrence. Furthermore, what is fascinating are the arguments about the economic impracticality of death punishment. While these arguments are more complex in Western countries, today we will learn a more detailed explanation in the Indian context. The key aspects to consider from a legal and economic standpoint are the cost-benefit analysis of investing in a capital case, the resulting utility or disutility, and the opportunity costs associated with the death sentence. Now, let us learn about the connection between economic opportunity and deterrence. The debates that take place over the economic sustainability of the death sentence are inextricably intertwined with the purpose of deterrence that is meant to be served. As a result, we will also examine the arguments in relation to that particular aspect. During this class, I will do an economic legal examination of the issue surrounding the death penalty from an economic perspective. First things first, let's talk about the advantages of the death penalty, the deterrence effect. If the deterrence hypothesis is valid, the economic advantage would be the monetary worth of preventing a murder. The reduction in the murder rate leads to a drop in total protection expenditures, which is advantageous for society. Moreover, the prospective target has the ability to make a valuable contribution to the productivity of society during their whole professional career. Preventing any homicides will enhance the overall efficiency of the country. This theory posits that criminals are individuals who want to maximize their utility and make logical decisions. Nevertheless, opponents of the death sentence have strongly criticized this concept and its underlying assumptions. The correlation between the harshness of punishment and its deterrent impact is a subject of intense debate, particularly when considering that as punishment becomes more severe, hardened criminals assume the role of decision makers. Assessing the deterrent impact of the death sentence is particularly challenging due to the inherent difficulty researchers have in quantifying the numbers of potential murders that are prevented. Now, let's have a look at the historical study that has been done on this subject. Economist Isaac Ehrlich conducted research on the data collected from the robberies that took place in the 1940s, 1950s and 1960s in the year 1973. Taking all other factors into consideration, he discovered that the likelihood of being convicted of robbery was inversely proportional to the rate of robbery. Despite this, he discovered that the harshness of the penalty did not determine the level of deterrence between the years 1940 and 1960. By analyzing robbery records from the year 1950, he discovered an intriguing phenomenon, a deterrent effect that was dependent on the harshness of the penalty. The death penalty research project and the New York Times conducted a comparison of states that are capital and those that are not capital in order to evaluate the effectiveness of deterrence. The inquiry looked into the number of homicides that had taken place in the state of New Jersey both before and after the state passed a law that authorized the use of death sentence in 1982. An investigation revealed that there was no statistical meaningful reduction in the number of homicides that took place. The possibility exists that those who commit murder are not logical decision makers. Despite the fact that individuals may be aware of the anticipated advantages and costs of their activities, it is possible that they will not respond in a manner that maximizes utility. After that, let's go to the cost-benefit analysis of the death penalty. In this part, we shall make it a goal to do an exhaustive analysis of the economic impact of the death penalty. The purpose of this investigation is to determine if the procedure for carrying out a sentence of death penalty is considerably different from other sentencing choices, such as life imprisonment, particularly with regard to financial expenses that are spent over the course of a case involving the death penalty. In addition, we will investigate whether or not the substantial expenditures that are incurred are justified by the usefulness that is meant to be obtained via the upkeep and execution of cases involving the death sentence. In the case of a death sentence, the primary benefit that is sought is without a doubt the deterrent of the offence for which the sentence has been inflicted. For the purpose of providing context for this research, it is essential to place an emphasis on the crucial role that deterrence plays in the discussion that surrounds the death penalty. When it comes to discussion on the effectiveness and morality of the death sentence, the subject of deterrence is at the center of conversation. Despite the fact that there is a wide range of opinions held by academics, jurists and politicians on the real deterrence impact of the death penalty, it continues to be a primary emphasis that influences policy and legal frameworks all over the world. Various points of view on the effectiveness of the death sentence as a deterrent are provided by empirical research and historical facts. Jurisdictions such as Texas, which has traditionally had a high rate of executions, for instance, claim that the possibility of the death penalty acts as a deterrent to the commission of heinous crimes such as homicide. On the other hand, states such as New York and New Jersey, which have abolished the death penalty owing to concerns over its cost and efficacy, highlight the lack of clear evidence supporting the utility of the death penalty as a deterrent. This was stated by Dieter in 2017. In addition, the economic aspects of deterrence include not just the immediate expenditures that are connected with the trials and appeal for the death sentence, but also the broader social repercussions that are linked with the death penalty. A number of these include the distribution of financial resources that have the potential to be diverted into preventative measures, rehabilitation programs, and victim support services with the goals of improving public safety and lowering the rate of recidivism. First, let's have a look at the cost of a death penalty. What constitutes the cost of a case involving the death sentence includes more than simply the expenses associated with carrying out an execution. It must necessarily include the expenditures that the state has expended during the entirety of a case in which the maximum punishment that may be handed down is the death penalty. Therefore, it is not required that the act of carrying out the sentence itself cost a significant amount of expense. This includes the form of execution, the plans for it, and other related matters. A case that involves maximum sentencing of the death penalty is likely to have a cost that is significantly higher than the cost of any other case in which the death penalty is not the result under the rules governing criminal offences. From the moment that a lawyer is hired in a possible case involving death sentence, costs are assessed on an ongoing basis. In order to arrive at this knowledge of the cost of case involving death sentence, there are two fundamental reasons. In the event that a trial for the death penalty is conducted, legal systems all over the globe provide extra procedural protections. In the event that a trial for the death penalty is conducted, legal systems all over the globe provide extra procedural protections. This is due to the fact that a sentence of death is distinct from other punishments in terms of its absolute irrevocability. It is the life of a person that is at risk, and therefore legal systems attach riders to the act of pronouncing a death sentence in order to take these factors into consideration. For instance, after the ruling in Bachchan Singh versus State of Punjab, it has been established as a standard in India that a death sentence should be issued only in the rarest of rare cases where other possibilities have become unquestionably foreclosed. In the case of Gregg versus Georgia, the United States Supreme Court made the observation that the penalty of death is different in kind from any other punishment. For reasons that are comparable, the additional procedural protections that are present in a trial for the death sentence set it apart from other types of criminal cases in terms of the amount of money that the state must spend on the former. These expenditures are significant due to the fact that not all cases that include the capital penalty result in a pronouncement to that effect by the courts. And not all death sentences that are declared by the courts result in executions. On the other hand, as was said previously, regardless of these potential outcomes, the additional costs begin to accumulate from the moment a trial for the death sentence is initiated. Next, we will talk about the economic analysis of the death penalty. Now, the economic study of the death penalty is significant not just due to the cost involved, but also because in the majority of the cases, these expenses are rendered useless, as only a small fraction of genuine death sentence cases actually lead to executions. It should be noted that any concerns about the expenses associated with the death sentences can be readily addressed if the intended deterrent effect is accomplished by paying these expenditures. Thus, while this part aims to comprehend the reasons behind the high expenses of the death sentences, the next section emphasizes that these costs are ultimately futile expenditures as they fail to accomplish the desired utility of deterrence. Now, let us comprehend this from the nature of these costs. Prior to delving into the wastefulness and the lack of usefulness of the expenses involved in a death sentence case, it would be beneficial to analyze the nature of these expenditures. The imposition of the death penalty is accompanied by a heightened level of procedural and substantive protections distinguishing it from regular criminal proceedings. In its most recent report on the death penalty, the Law Commission of India characterized the Indian practice of imposing the death penalty only in the most exceptional and extraordinary cases as one of the most rigorous and persuasive standards in criminal law, marking the initial stage of constitutional regulation of the death penalty in India. Similarly, throughout the United States of America, it has been observed that the primary factor contributing to the high cost of the death penalty may be succinctly explained by the phrase death is distinct. Therefore, a death sentence case requires a higher level of meticulous and thorough procedural adherence. In the Indian context, once the Court of Sessions has given the death penalty, the legal process moves forward with the procedures in the High Court followed by processes in the Supreme Court of India. There is further potential for considering review and curative petitions up to this point. The death sentence trial may not be significantly distinguishable from other severe criminal offences. Furthermore, there are other measures in place to ensure safety, such as the President or Governor's authority to grant pardons and the Supreme Court's ability to evaluate the executive's use of pardoning power through a writ petition. Furthermore, following a lengthy procedure, the Home Ministry has established additional measures to protect death row convicts under the procedure regarding petitions for mercy in death sentence cases. These precautions demonstrate an acknowledgement of the permanent and unchangeable character of the penalty. A non-standard death sentence trial necessitates spending money on hiring specialists to analyze forensic evidence and investigate the defendant's mental well-being. Although these fees are not limited to death sentence trial, it is necessary to thoroughly analyze and gather mitigating and aggravating evidences. Mitigation specialists investigate several elements of the defendant's life, including conducting interviews with the family, co-workers, teachers, physicians and others. In addition, a court must conduct an independent examination of this testimony and correlate it to the aggravating circumstances, which also requires expert evidence. The defendant's mental state during the commission of the crime is a pertinent aspect necessitating expert evidence from psychiatrists. This decision alone may lead to significant costs, and a successful decision serves as a mitigating element. The majority of the preparation for this presentation must be completed beforehand, regardless of whether a sentencing trial is required. Inadequate states incur subsequent expenses when judgments are invalidated, necessitating the repetitions of proceedings. Moreover, the duration an incarcerated individual spends on death row contributes to the expenses associated with the death penalty case, particularly in instances involving offence against the government. As an illustration, legislative panel in California observed that the state incurs an additional expense of $90,000 per year for each convict on death row, in contrast to the expenditures of housing the same inmate in the general population. The presence of more than 670 prisoners awaiting execution results in an extra expenditure of $60 million annually, which may be directly attributed to implementation of the capital sentence. Now, let us investigate the opportunity costs of the death penalty. After calculating the financial burden of the death sentence on the state's treasury, we may consider the potential benefits lost by keeping it in place. Eliminating the death sentence would allow for the redirection of the valuable employee hours towards other productive endeavors such as the modernization of our courts, enhanced training for our police forces, improved infrastructure in our prisons, or investment in other state initiatives. Thorough cost analysis considers these opportunity costs and recommends reallocating resources to effective rehabilitative and reformative components in the criminal justice system, which may have a more enduring effect than any alleged deterrent effect of the death penalty. let us examine the impact of cost on executions. Now, the economic considerations have frequently hindered the implementation of executions. For instance, in the United States, the death penalty has been recognized as a highly costly and inefficient initiative. The research titled Smart on Crime, Reconsidering the Death Penalty in a Time of Economic Crisis, published by the Death Penalty Information Center, emphasizes the financial burdens that states have as a result of implementing the death penalty. States such as New York and New Jersey invested more than $100 million in a system that did not result in any executions, and both states have lately discontinued this practice. Amidst the 2008 economic downturn, 11 state legislatures deliberated on proposals aiming to abolish death punishment, with the substantial expenses associated with its being a prominent aspect of these discussions. The American Bar Association study vividly demonstrates the profound effect of the recession on the criminal justice system. The inefficient allocation of funds for jail maintenance resulted in the premature release of inmates and the termination of police personnel, posing a significant risk to the fundamental concept of justice in the United States. For example, in New Jersey, the reduction in funding in the 1991 resulted in the termination of 500 police officers, while around $16 million per year was allocated towards the implementation of the death sentence, which could have been used to employ the same number of policemen. In Florida, a reduction of $45 million in the Department of Corrections budget led to the premature release of 3,000 prisoners. Additionally, by 1988, the state had allocated $57.2 million to carry out the execution of 18 individuals. According to estimates, the cost of executing a person in Florida is 6 times more than the expense of imprisoning a prisoner for life without the possibility of release. The financial resources allocated to the implementation of the death sentence might be reallocated to support the recruitment of more law enforcement personnel, the construction of correctional facilities, or the resolution of unsolved criminal cases. Now let's conclude for this lecture. The economic analysis of the death penalty reveals significant insights into its cost and utility within the criminal justice system. Throughout this lecture, we have explored various dimensions of how the death penalty impacts state finances, societal resources, and the effectiveness of deterrence. In essence, while debates over the death penalty often evoke deeply held moral and ethical considerations, the economic perspective provides a pragmatic lens through which to evaluate its societal value. The considerable financial investments required for the death penalty, coupled with its uncertain deterrent effects and opportunity costs, challenge its continued viability in contemporary criminal justice reform efforts. As societies strive to achieve greater efficiency, equity, and effectiveness in their legal systems, the economic arguments against the death penalty gain relevance in shaping policies that prioritize both fiscal responsibilities and justice delivery. With this, we come to the end of today's lecture. Thank you very much.